based off of something they read online or like through a family member or friend that dealt with probate. And whether or not that's actually how it's supposed to work, I think, is a different story. So there's a lot of myths that we run into that are not how probate's supposed to work, or at least if it was done that way, it shouldn't have been. So we're going to go through the key ones with you today. But before I do start talking about that, just a couple quick things. As always, this is interactive. So if you're participating today, you can submit questions via the Q&A function on Zoom, and we'll see that pop up. You'll also be receiving an email at the end of this with a couple of things. One is a handout from us, and another is a feedback form. So the email you use to sign up, keep an eye out there. The handout today is actually on our estate planning and probate myths topic. So it's a chart or I guess a list of myths that we tend to deal with and run into quite frequently. And then the feedback form is a place for, of course, for you to give feedback and maybe list any topics you'd like to hear. But it's also a place for you to let us know that if anything we've talked about today makes you want to come in for an initial consultation and talk to one of us, that's where you can let us know to reach out to you so that we can actually schedule that appointment. If you would like us to reach out to you, that's the way to let us know. And we do schedule those for 2 hours. They are complimentary initial consultations, so it doesn't cost anybody anything to come in and talk to us initially. By the end of that meeting, we can usually give you a pretty good idea of what we recommend and what the estimated cost would be. But it doesn't cost you anything to come in and talk to us initially. Getting started, our topic today on probate myths, estate planning myths. I'll start with the big one, the one that we kind of advertised this as, and that's, do my children inherit my debt when I pass away? And the good news is that as long as things are followed appropriately, and barring somebody being on as a co-signer on a loan or like on a mortgage, they're not responsible for your debt when you pass away. But there are a couple really important things to keep in mind when you're looking at that fact. So in order for that to be the case, if you're going through probate, there's certain steps that need to be followed. So there, as part of the probate process, one of the big things that the personal representative or the person in charge of your estate has to do is give public notice to potential creditors. So they have to say that, John Smith passed away, and if you're a creditor, you have this period of time to come forward and file a claim against his estate. And you also have to give direct notice to known creditors. So you have to give public notice to any potential creditors that are out there, and direct notice to known creditors. So as long as that step is followed, and if those people do come forward, they can file a claim against the estate. I mean, that is something that if there's funds on the estate that are available for that purpose, and some creditors come forward, they do have to be paid. But the benefit of that is, even if there's not enough money to pay off all of those creditors, if there's not enough money in the estate, which is what we would refer to as a deficit estate. So it's sort of like your estate is filing for bankruptcy. In those circumstances, as long as all the steps were followed properly, the personal representative doesn't have any direct obligation to pay off those expenses. They're not liable for the debt. The children are not liable for the debt. They're not responsible for it. Now, like I said, there are some exceptions to this if things don't go according to plan, or depending on how those loans or debts were set up initially. So if somebody is jointly responsible for a debt, like somebody was on the mortgage or somebody was co-signed on a loan, they do have some responsibility for that still. That's not going to wash away just because one of the other, responsible parties passed away. They will still be able to assume the debt, or somebody's got to pay it off, but that's not just going to go away. The other really common issue that we run into is when people have received Medicaid assistance, in a nursing home, skilled nursing facility, assisted living facility. Basically, if they've received Medicaid assistance in connection with long-term care services, they will have what's called estate recovery potentially. Estate recovery is when Medicaid, the state Medicaid, program can recover as a creditor of somebody's estate. They can recover up to the amount that was paid out in benefits. So if that happens, if the Medicaid estate recovery does file a claim against the estate, then we can always be prepared that, there's going to be some amount of funds that are subject to that estate recovery if there is somebody basically didn't use an irrevocable trust. So if that happens, and maybe somebody didn't follow the proper steps, whether that personal representative, nobody notified estate recovery, or nobody, something was payable on death and all the kids spent down the money, estate recovery should have been entitled to some of those proceeds. So if that happens, there can be situations where if those steps weren't followed properly, estate recovery can come back and say, well, hold on a second, that money should have been used to pay off our expenses or our debt that was owed. And if it wasn't, there could be some liability for that. So there are circumstances in which if somebody doesn't follow the proper steps, it's not so much that the debt is inherited, it's that they're liable because they didn't follow those steps properly. There are some states, so Wisconsin is not one of those states, but there are some states that do have what's called filial responsibility laws, which are sort of like saying you still have to make sure mom and dad are taken care of and help pay for their nursing home or potentially pay down their debts, right? Those states vary in how they apply those rules, of course, but some states do have laws on like inheriting debt. But it is not always the case. I mean, it's not going to be the case across the board, state by state. It'll differ. And thankfully, Wisconsin is not one of those states. So really the only way in Wisconsin that somebody can be responsible for somebody's debt after they pass is if they were a co-signer on a loan, they were jointly responsible for it. If they didn't follow the proper steps after someone passed away, so like that personal representative, if they didn't give proper notice out, if they, I guess, committed fraud in any way, right? If they did something to avoid paying the debt as they were supposed to, they could be personally responsible. And if the kids received things via payable on death or transfer on death, through beneficiary designations, if that's how that was transferred and the decedent, the person who passed, was on Medicaid and received Medicaid assistance in connection with long-term care services, and they didn't tell Medicaid's estate recovery program about that person passing or about the money that was given out to those individuals, and that money is gone, they can then become responsible for it too. So the moral of that story is, it's not that you inherit the debt, but you do need to be very careful about following the right steps. So I've I guess this is less so a myth, but one thing that I had somebody bring up to me once where they said, well, hold on a second, we didn't have to do any of that. We didn't have, the whole probate process only took 2 weeks. And what that tells me is that something wasn't done properly, because that process is never going to be that short, or almost never going to be that short. And part of the reason for that is there's certain timing requirements just in of themselves that are longer than those, that 2 week period that this individual is mentioning. So another really common myth in terms of probate is, I think, how long that process can take. And some people have heard, variety of lengths of time when people bring this up to me, but it is common for probate to take about a year on average, if not a year and a half, depending on the context and like the complexity of the estate. And part of the reason for that, so I mentioned that notice to creditors, that in of itself is a 90-day window that they have to come forward. So that's 3 months, right? So that's why that 2 week period of time that individual mentioned didn't seem quite right to me, because something wasn't followed there, right? So probate is a lengthy process, and part of that is a lot of hurry up and wait. It's not that people aren't trying to get this done sooner. It's just that it is a lengthy process because you have certain windows that have to be met. And you have to wait until that window has passed, the creditor window in particular, to go to the next step and really start giving out, potential distributions to beneficiaries, filing receipts, and inventories and all of that. So it is a process that can take some time. One of the most common myths, I think, that we run into with probate, probably more common than the inheriting debt question, is whether or not somebody's estate is actually subject to probate. So very commonly, somebody will ask us when we're talking about wills with them, that, they had heard that wills don't go through probate, that, if you have a will, you're not going through probate. Probate is only for people without planning at all. And it's actually, unfortunately, it's incorrect, and wills do go through probate. That is, in fact, the only place that wills have any direction at all. You cannot have a will just dropped off at somebody's bank and say, see, this is how we want things done. They have to submit that will to probate first in order for any of the provisions of that will to have any legal bearing. So it is very common that we run into people who don't understand this and maybe have a will, but then have all of their assets avoid the probate process by using things like payable on death or, transfer on death designations. And then they don't understand, or the family doesn't understand then when that person passes, why the provisions of the will didn't apply. So in order for your will to have control over your assets when you pass away, you need to have those assets subject to the probate process. So that's not to say that everything you own would actually go through probate. Depending on the type of asset you have, sometimes it's not ideal. But it is very important if you have planning in your will for things like children with supplemental or special needs, or any sort of like rules you want followed with the inheritance. If you want those rules to apply to the assets that you're passing on, you have to use probate because that's where the will be followed. In that same vein, just because somebody is nominated in the will as that personal representative or the executor, if you're more familiar with that term, just because they're nominated there doesn't give them immediate ability to act. So that's where oftentimes people are concerned about, well, how do I pay bills after mom and dad pass away? Kind of leads me into our next myth of, if somebody is acting as a financial power of attorney during mom and dad's lifetime and they were the ones paying the bills, it is a really common misconception that they continue on in that role after they pass away. Powers of attorney end at death. So the authority in them ends at death as well, meaning that if you are the financial power of attorney paying bills while mom and dad are alive, you can't just continue on in that role. It ends at that point. So that's where you do have to be named either as a trustee of somebody's trust, if that's the document they're using to pass assets, or as the personal representative in that person's will. If you are named as a personal representative, or nominated rather as a personal representative in that person's will, you still don't just take the will down to the bank, like I said earlier, because that, they would say, still come back later when you've done the right things and followed the proper procedure. In order to actually be nominated and approved as personal representative, you first have to give the will to, submit it to probate, admit it to the probate process. The court will then make sure that public notice or a notice to the interested parties rather will be given on who is nominated as that personal representative. So just because you're named in there again doesn't mean you will automatically be approved. As long as everybody signs off on that process, the people who are inheriting under the will, or the people who would inherit under the will if the will were invalidated, those are the people who have to be told about who's nominated. As long as they sign off on that process, it's a relatively quick transition. Can take up to about a month for it to be finally approved if people aren't signing off very quickly. But a month is basically the end date to that. The court will give a hearing notice if people don't sign off by that point, and approve them if nobody objects. So if somebody objects to that appointment, it can of course take longer than that. But that approval process, once that's finished, the court will grant what's called domiciliary letters to that individual. An easy way to think of that is it's sort of like saying, here's the slip of paper or the authority or the badge that says you can do what you think you can as that personal representative. You have the authority to act financially and pay bills and open estate accounts and file taxes for the estate, all of that. So that's when that individual can finally act in that process. So once those letters are granted, that's when the bank would say, okay, now you can set up an account, or now you can start unfreezing these accounts and paying bills. But in that process, before that person's approved, it can be that a lot of these accounts are frozen during that period of time, and therefore bills aren't getting paid. But that isn't as scary as it sounds, because, as I mentioned earlier, there is a period that the creditors have to come forward, and it's a requirement that you follow that process under the probate process, is to give that notice. So just because they have to wait doesn't mean that they won't get paid. And they should not then be personally coming after like the family or the personal representative as creditors and saying, you have to pay us now, because there's going to be a period that they have to come forward and file a claim. So when it comes to bill paying, that personal representative will have to be officially approved by the court first. Just being named in the will isn't going to help them, because that doesn't give them any immediate access. It's a nomination to that role. One issue we have with bill paying in general when it comes to probate is it's very dependent on what assets are actually subject to the probate process. So as I mentioned earlier, there can be, if you want your assets to follow the terms in your will, you have to actually have them be subject to the probate process, because there's no guarantee that outside of probate transfers will follow your intent. Then if your will is different than maybe you have beneficiaries on an account. So we often get asked about like payable on death, transfer on death designations, and whether or not those avoid probate. And it's true that like beneficiary designations on retirement accounts, payable on death, or transfer on death designations on assets, those do avoid the probate process. They transfer directly to the people listed on those accounts as beneficiaries, or to the charities if that's what somebody listed. It's also true that joint owned accounts will pass to the surviving joint owner in most circumstances as well. So those avoid probate as well. But the problem people run into is whether or not that by itself is actually a good idea entirely depends on what their estate plan is. If that individual has a will as their estate plan, that's the document they're using to pass assets, you want some assets to go through probate. You don't want all of the assets beneficiary designated. Whether or not those assets are actually following the provisions of the will, the percentages in the will, that's one part of it, but it is not the whole process being followed correctly. With a will, the benefit of having certain assets go through probate is then that personal representative that's maybe approved at that point, they have access to those funds that are part of the probate process in order to pay bills, in order to pay expenses of the estate. And if all of the assets have avoided that process, that person doesn't have access to those funds. It might already be that they've been given out to the beneficiaries, and maybe that person is one of the beneficiaries, but maybe not. And if that's the case, they may try to go back to the other people who've inherited and say, hey, we still have bills to pay, and I don't have access to these funds as personal representative. Can you help me pay these bills? But the recipients of those funds through payable on death or transfer on death designations are not suddenly responsible or obligated to give that money back to that personal representative. They'd have to be gifting that money to do that. And whether or not they want to is part of it. Some people don't want to, but they also may not be able to if the recipients of those funds are receiving things like means tested assistance through Medicaid, or maybe they have creditor concerns of their own. You can't gift money in those situations. So you want money as part of the probate process in order to actually have the bills guaranteed to be paid, right? The other problem and sort of the other side of that is when people then leave assets all to that personal representative. Maybe they name them directly on an account as a beneficiary or as a co-owner because they don't want that period of time where that person doesn't have access to those funds. That may sound like you're getting around that problem of bill paying and giving direct access to the personal representative and not having things divided out first. But the problem with that is now they are the owner of those assets when you pass away. They don't have to share it in accordance with the will, or they, again, may not be able to, depending on their situations of liability. So making sure that things actually are subject to your will and subject to the probate process is really important if you want two different things to really be guaranteed. One, that the personal representative not only has access to funds to pay bills, but has to use it for that purpose and share it in accordance with your will, but also to guarantee that after the bills are paid, then everything gets divided equally. That means that everybody shared in those expenses proportionately, and that, when things are divided out as a beneficiary designation and bills haven't been paid yet, well, initially they got the percentages that that person wanted, but ultimately do they end up with the final results being what they intended? And sometimes not, right? If somebody doesn't take their fair share of expenses out of what they've received, they may not have, or they may have more rather than the other individuals because they didn't share in those expenses. And they're not obligated to. So making sure that your assets actually follow the probate process, if you're using a will, can be really important. There are exceptions to what you would want to go through probate. So for example, you would generally not have a retirement account going through probate, like an IRA or a 401k, because that can trigger negative tax implications depending on when that person passes away. Certain situations where we have done that because there were just so many beneficiaries that, triggering a shorter payout for those retirement accounts, it didn't really matter. They would all be taking that money out immediately, almost certainly. But that can be, a case by case situation. In most contexts, if somebody just has 2 kids, they're not going to leave their retirement account through the probate process. That could be a huge negative tax implication for them. So just, the big takeaway from that is making sure that if you have a will that is subject to probate, so it's a myth if you hear that it is not subject to that probate process. People often think that it's only for people without estate planning documents at all, so without a will or without a trust or without beneficiary designations. And in that context, if somebody has no planning in place at all, those assets will be subject to probate. That estate will still go through probate. But probate is both the process for people with no planning at all and people who have wills as their intended plan. So it's not an inherently bad process either. And I think that is also a really common myth we run into with probate, is that it is this process that you want to avoid under all circumstances. At no point would you ever want your estate to be subject to probate. And that can be the case for depending on your circumstances. It might just be a bad idea to go through probate because you might not have any need for it. You might be better served by using a trust to pass things outside of probate, for example. But probate can be an absolutely perfect process for the right people. And there's really 3 main, scenarios in which you would really want to be using probate, at least for part of the administration of your estate after you pass. First and foremost, I mentioned that creditor process and whether or not people inherit debt. That is the perfect use for probate. If you have a deficit estate, if you don't have enough money to pay off all your debt at the time you pass away, whether that's due to Medicaid estate recovery, whether that's just due to other debts, probate is the perfect process to deal with those debts, because then that everybody's followed the right procedures to give notice to these creditors to get them paid what they could. And then that everybody else is off the hook, that the beneficiaries aren't responsible for it, that the personal representative isn't responsible for it. So you're making sure that if you have more debt than you have assets, nobody else is going to be responsible for that. That is a really common use for probate when somebody has that deficit estate. When you have minor children is a really common reason to have somebody go through probate. So when you have minor children, you're nominating guardians to take over for you after you pass away, you have to do that in a will in order for that to have any bearing. So in the probate process, the court is who's going to approve those guardians and really make sure that they're actually fit to serve and fit to be parents, parent-like guardians, right? So you have to name guardians in your will if you want that, the people you would want to be acting as guardians, if you want them to be kind of put at the front of that line. Now, that gives people, again, the opportunity to challenge those appointments and say that that person isn't fit, but that's the entire point, is the court wants that process to work that way. You want to make sure that these people are fit. And in most cases, I'm sure they are, but if you want your suggested guardian to be kind of put at that front of that line, that is how you do that, is you name them as or nominate them as guardians through your will. That doesn't always mean, though, that just because you're doing or using probate for that purpose, for the nomination of guardians, that doesn't necessarily mean that you're going to have your assets go through probate. It just means you're using it for that process. There's a lot of situations where depending on the size of the estate, the types of assets that someone has, we might be naming guardians through their will for their minor children, but still using something like a trust to pass all of the assets. So it just depends on the situation. Another reason to use probate is if you have certain provisions in your will that you need to be followed for somebody, and that it would be really dangerous for them not to be followed. So that would be, for example, when you have young adults who you want maybe to have a higher age requirement in order to be in charge of their inheritance than just age 18, or you have a child with supplemental needs who has means tested assistance and would lose access to their benefits if they received that money directly. That is a really important thing. If you have that planning in your will, if you want the assets to actually follow the provisions in there, you need to use probate for that trust or those restrictions to be put in place. You can't just say, well, my will said it, but we never went through probate, so therefore it should still be followed just because the will said it. You have to have the probate process followed if you want those provisions in the will followed too. So sometimes it's not just about bill paying, sometimes it's not just about nominating guardians, it's also about ensuring that your intended result in your planning actually happens. And I think that's the most dangerous myth of all, is that the will is going to somehow direct things no matter what. Like it has bearing just because that's what somebody said in their will. And you would think that's the case. That's what most people think if they don't do this for a living, I suppose. But they still need that will admitted to probate in order for those provisions to be followed. And then I guess just I'm running short on time here. So just a couple quick things again. Keep an eye out for that form on estate planning myths and our feedback form, which gives you a place to let us know if you'd like us to reach out to you, rather, to set up an initial consultation, which again are complimentary and scheduled for about 2 hours. And then next week, our topic is actually going to be on planning around long-term care costs and things that somebody could do to prospectively plan for that, whether that's through financial planning, legal planning, or like insurance planning. There's a lot of options available to people, and just what you should be looking out for. So that'll be next week at the same time. And then the following week is just the week of the 4th. So that everybody's off that week anyway, so we're not going to be having one that week. Anyway, if anybody has any questions that come up through this or would like us to reach out to them, please feel free to fill out that feedback form and let us know. Otherwise, I hope you guys have a good rest of your day and enjoy the first day of summer.